much. And welcome everybody, and thank you for coming back after coffee and cakes. It was too good to miss, wasn't it? So just to let you know, I'm Katharine Davies, and I'm a part of Pinsent Masons based here in London. Pinsent Masons is a global law firm, and we have offices throughout Europe, Middle East and Asia Pacific. And I mainly either litigate or arbitrate, and it's about 50-50 with a little bit of dispute resolution thrown in, just because one has to do it. We'll go no further. So this session, which is litigation versus arbitration, the pros and cons, is really fitting that I should be actually introducing it. It's a very interesting, but also I would say a very frustrating topic, as highlighted by both Wolf and John in the first session, because in this jurisdiction, and I obviously wouldn't comment on others, those who draft the contracts really have very little to do with those who arbitrate and litigate. And so when it comes to dispute resolution clause, the one thing people don't sit down and do, I mean sometimes, and they're getting better, is to ask, what is going to be the appropriate clause. It's the we just need to get this signed off, because it's about clause, it's on page 44 or page 88 or whatever it is, depending on the contract. So it's only really when the dispute happens, people say, well, why didn't we have this conversation at the time we did the contract? And that's a really sensible thing to say. And I think that probably is incumbent on us practitioners who are in the dispute realm to probably go and spend some time with our non-contentious colleagues and actually explain to them, the advantages of actually thinking about these issues earlier rather than later. And there was a very good comment that John made, which I actually made a point about, is that, this changes all the time. What may be good for your contracts today, in about 6 months' time or a year time, depending on your business and global political intervention, may be something completely different. So today, I'm really looking forward to having some insights as to some new arguments that I can actually go and say to people, this is what we should be thinking about before you sign, rather than before the ink dries. We have 4 excellent speakers this morning. The first speaker is going to be Dr. Thomas Rihm, who we all remember because of our lanyard sponsors. And Thomas is the managing partner of Rihm Associates, which is a Swiss-based practice in Zurich, and represents foreign investors from many jurisdictions in many industries and sectors. Obviously a leading dispute resolution in his field, and he's going to sort of take us from the beginning, talking about the interaction between the state courts and arbitral tribunals, in particular looking at what we call preliminary injunctions, interim relief, which is quite important, and also he's going to talk to us about language, and it's going to be clean language, not bad language, I hope, Thomas, anyway, but here's some good jokes. Our next speaker will then be Michelle Taylor. Michelle is, as has been indicated, is the General Counsel and Department of the U.S. Air Force, and she's based in Texas, though she is from New Jersey and likes to travel. And it's her first visit to London, so welcome to London, Michelle. And I hope you come back again, because at least we give you some decent weather for a change. That's a good thing. And Michelle has a very varied role, as most in-house counsel do. She negotiates, she does do drafting, she also advises on policy and regulations. And so she's going to be covering a brief history of arbitration and the key elements that are required comparing to litigation. Our third speaker is Matthew Sava. Matt is from New York and has been in the litigation business for 24 years, starting his career in Scandinavian, and then became a partner in the New York practice for 15 years, litigation partner, and then after being a GC is now the head of litigation at Reid and Wise, another of our sponsors. I just get that in. But Matt currently, his practice has offices in New York and Los Angeles and Shanghai, so they obviously deal with litigation and arbitration globally. And Matt is going to cover, I think, a really important subject for all of us when we are discussing this with our colleagues, which is enforcement, how the difference between enforcing a court judgment and an arbitral award, which I think is, after all, spend all that money if you can't actually get your money back at the end of the day. Really, was it worth it at the end for doing it? And then our last speaker is Abhijit. I'm not going to pronounce his surname, if you don't mind. Not to worry. Not to worry. Abhijit is the president, lead president, and general counsel of the Hinduja group, which for those who don't know, but I'm sure you all do, is a global conglomerate, has headquarters in London, has offices all around the world. I think it's probably 30, 40 countries it works in. And from the website, it tells me it employs over 125,000 people. So that's a huge, huge workforce. Abhijit is what I'd call the GC's GC. I mean, he has got more accolades than anybody could hope to have. And I won't go through them all because, I mean, you'll find them in the speaker's notes. But the one I liked was he's one of the top 99 general counsels out of 31 countries, which is a huge achievement. And I think it's a real honour to have you with us today, Abhijit. And Abhijit's going to come in at the end and talk about the client's perspective, which, as we've all discussed before, is incredibly important. Because, you know, you can have all these academic debates, but when it comes down to what does the client really are they looking for litigation or arbitration, and how they prepare for this, and probably in most cases, as already been forewarned, how they can avoid the disputes in the first place or get rid of it as quickly as possible. So I'll hand over to the speakers. I hope we'll get some Q&A afterwards, so please write down your questions when you're going through, so perhaps we can have a bit of a lively debate when we get to the end of the talk. So if I go to Thomas first.
Yeah, good morning, everybody. Thanks for coming. It's a great conference so far, and I'm very pleased to sponsor to speak. It's a great event. Perhaps you have looked at the flag here. So we have 3 colleagues from Switzerland, but they're sailing under a somewhat exotic flag, which is not the white cross, red background. 2 important things were actually addressed already at this stage. One is really if you have, you know, a complex contract framework to negotiate, and at the very end the parties are in agreement, you know, and then there is not a lot of energy, and the parties are not in the mood actually to discuss the structure when things go sour, and they're also not really willing, you know, to discuss for 2-3 hours the potential dispute solution structure. This Katharine addressed that. The other thing is actually execution, and Matthew will speak about that. That's sometimes, you know, people are focused on arbitration versus state courts, but the whole idea as to how you execute at the very end is left open, and then there is sometimes much disappointment when you have actually a title, but you cannot at the very end execute with that title. Very frustrating. So that's also an important topic to discuss. I start with language, actually. Perhaps that's a not so very academic approach, but it's a very practical approach, and it fits into discussion about state versus arbitration. I mean, you really have to analyze, you know, what language the parties speak, what the language will be in operating the contract over the next 2-3 years, you know, what is the document language, and so on and so on, the parties involved, you know, and there it really can make sense to define the potential language under which disputes would then be solved at the very end. And it's obvious you have an advantage with arbitration because you can actually choose, as we all know, the language of arbitration. And this has indeed many advantages, of course. You know, people can really plead, if necessary, in their own language, which is mostly English, of course, French, sometimes German, but English is, as we all know, the predominant lingua franca in the business world, and so it's not only a question of pleading; it's also a question of, you know, the whole documents. If you have, you know, whatever 80 binders of documents, that you should all of a sudden plead and translate that into Kishueli or Swedish or Italian or whatever, that makes things complicated. It makes them very costly. So if you see, I mean, that the contract language is English, it really makes sense to look for a dispute resolution mechanism that is commanded by the English language. So again, there is this obvious advantage of arbitration where you can choose against state courts that are required to run a court proceeding in their official language. I mean, there are now, as you might have heard, efforts. Amsterdam has introduced actually commercial court that where you can, it's a state court, where you can plead in English. Switzerland is also considering, at least at the Supreme Court level, to admit the English language as a formal official language. This is of course a little bit disputed by the Swiss professional community. I mean, lawyers, Swiss lawyers think that the Anglo-Saxons might take over, at least at the top end of the Swiss jurisdiction. So this is much in discussion. There are other jurisdictions actually introducing or considering these English courts, if you want, English-speaking courts, and that's quite an interesting aspect. So if you schematically, compare arbitration versus state jurisdiction, and you come up with the language issue, consider, whether this still applies. This is one aspect of my speech. The other one is actually, preliminary injunctions, as we all know them. The question is, of course, and this is one of the disadvantages of arbitration, that you don't have a court. You don't have an arbitral tribunal in place when the things start. And when things start, quite often, preliminary injunctions are essential in securing, at the very end, the litigation success. We all know that, and there is an obvious advantage of state courts which are in place, where you can file, where there is a judge who can consider perhaps the next day or within the next days your request for preliminary injunction. I think that's a clear advantage of state courts. A second aspect, whilst of course, in arbitration you have to make your request, then there's the big squabble, 1 or 3 arbitrators, then there is the big squabble about, first mediation, then arbitration, then there's a big squabble, as to how to structure the whole arbitration process. And of course, the struggle about appointing the arbitrators to put a court in place, and this can take time, and we all know that this is sometimes abused. So I think there's a clear, advantage of state courts because, as I said, they exist, and that can take these and consider these requests for preliminary arbitration. A second aspect to this is that if a state court issues a preliminary injunction, it can actually be executed, not only within the own jurisdiction of that court, but via the means of international judicial assistance. You can actually execute that in New York or in Paris or wherever. I think that's an important aspect. Whilst of course, arbitration tribunals can, once they are in place, can issue preliminary injunctions, but the question of execution is actually open. I mean, the arbitral tribunal has certain means, to to look for cooperation by one of the parties subject to the injunction by asking, for security, by considering the whole procedural behavior if they do not obey or comply with the injunction order. So there are, I shouldn't say informal mechanism, to secure collaboration, but at the very end, an arbitral tribunal, at least in Switzerland, has to, and I think it's similar in other countries as well, the arbitral tribunal, for its own preliminary injunctions, must actually secure the assistance of a state court. I believe that's might be a disadvantage to be considered. And then a third aspect is actually, no, I spoke about that. Yeah, I'm pretty much there, Katharine. So I hope I haven't.
Yeah, you did very good on
Okay,
time.
perfect. Thank you.
Michelle, thank you.
Great. Okay, good morning, everyone. And I want to talk a little bit more about, we've heard ADR and how arbitration is needed and certain things. I wanted to kind of go back a little bit on the history of it. Arbitration represents a choice of peace over aggression when we think of litigation these days. I went back as far as Native Americans used arbitration to handle disputes against tribes. In England, the merchants actually resorted to using arbitration outside of the royal courts for when they had national and international trade. So, and then in the States, in 1632, Massachusetts was the first state to use law supporting arbitration preceding Great Britain by 65 years. I thought that was pretty interesting. And dealing with Pennsylvania was the second in 1705, and in 1768, New York joined the group. So when we think about arbitration, it has gone back so long, and the importance of it, I think that's one of the things that we're stressing, that it is important to use it, but the key is it's been going on for so long, we're still trying to look at so many iterations of it as it continues to grow. So now when we think about coming forward to this day and age, we have like the federal labor disputes laws, there's so many aspects of it, and the question is whether dispute resolution, whether we should use it and how we should use it, and how can we continue to change it. Arbitration promises to be superior over court litigation because of confidentiality, presumed cost savings, and quicker results sometimes, and more flexibility. We think about the courts and the court systems, whether you're in an international or whether you're in the States, litigation can take a lot of time and efforts and money. Prior to me coming to the Air Force, I worked for Fidelity, and I managed a lot of outside counsel, and we worked a lot on disputes and how we could resolve those. In talking during the break, a lot of times the dispute clauses are just customary. We just kind of put them in there. We don't think about them. We just do it. And the next you know, it doesn't necessarily, focus on the different transactions that we have. So that's one of the things that we have to be more careful about. And one of the things that we try to do in lessons learned is make sure that we're actually using the arbitration clauses that are applicable to the particular transactions. So we know that each case is fact intensive and not one size fits all. So we know that certain cases, it's not going to be the same if you're dealing with commercial transaction over in Europe and if you're dealing with something in the States. So that's another thing that we have to be more mindful of. And again, there's frequent concerns about the cost. A lot of times my managers would say, hey, how much is this costing us and how can we cut this cost? Sometimes, it's very important not to get a bad decision, but sometimes it happens and there's nothing you can do about it. So, however, if we're going to court and we're dealing with tons and tons of litigation costs, we have to weigh the pros and the cons, and we have to be able to focus on that and understand the importance of the risk award, analysis, and making sure we're doing the best for our clients. Mediation tends to bring rationality and the right sizing up to the thinking of corporate decisions, making on both sides of the dispute. We need to be able to look at both sides and say, we may have the best facts in this particular transaction. That doesn't always mean we're going to win. So that's another thing. Depending on the jurisdictions, sometimes we say, okay, it's in that jurisdiction, we're going to go ahead and settle because we already know we're not favorable in that jurisdiction just because of the judge or just because of the circumstances. So these are things that we have to keep in mind as we're educating ourselves and how to properly use it in our business and how we deal with it in the drafting of it, and also being able to communicate. If we're not communicating with the different branches in our organizations, then sometimes we failed ourselves even before we've gotten out of the gate. So that's another thing we have to be mindful of. When we think about international arbitration, we have to think about the disputes and also those jurisdictions and the political ramifications and certain situations that could affect how our situation is dealt with in the first place and how it's going to be resolved and whether or not that's something that we want to take on. So these are so key elements, to keep in mind. I mean, certain things I know that I was doing in my research is saying international arbitration is becoming relatively certain to being able to enforce the award through the available international conventions like the New York Convention and things of that nature. So those are things to look at as well. So again, in dealing with arbitration, there's different tools that we use, but knowing that when you think about the history of this and how important it is and how it continues to have different iterations, it's important for us as lawyers to be able for our clients to use it in a sense of continue to produce and move forward with it versus us kind of saying we got a bad decision, we're not going to use it because of this or because of that. Everyone has a bad day. Everybody sometimes has a bad decision. We just have to be able to learn from those situations and be able to move forward and as we use arbitration. So that was my presentation. If you have any questions, we'll save till later.
Thank you.
Okay, I have a fairly rudimentary presentation here. Let's see.
Perhaps leave.
No, this is,
Oh,
okay. Good morning. I'll be discussing the enforcement of court judgments and arbitral awards. In deciding between arbitration and litigation, the ability to enforce any resulting award is a paramount concern. For a long time, the issue clearly and often decisively favored arbitration, although there are certain developments that have made this a closer call. Let's first take a step back to describe the broader context of the issue. The goal of the dispute resolution process, whether in arbitration or litigation, is to obtain a ruling that finally determines the rights and obligations of the parties. However, a ruling is simply a piece of paper. It's not self-enforcing. Unless a party voluntarily complies, the winner must resort to legal process to enforce the ruling. With respect to court judgments, issues of national sovereignty are implicated when trying to enforce a judgment in a different national court. Historically, the extent to which one country would recognize the judgments of other national courts was a matter of comity and reciprocity. Essentially, the courts recognized that if they wanted their judgments to be enforced in other countries, that they should do likewise. However, without formal rules to guide the process, the recognition and enforcement of court judgments issued by other national courts is unpredictable and subject to local bias. Arbitral awards, in theory, are on even shakier ground when it comes to international enforcement. An arbitral award is merely a determination by a non-governmental neutral selected by the parties to resolve a private dispute. Absent governing legislation or international agreement, the courts of a country could freely ignore the arbitral awards issued by a private party in another country with impunity. To meet these challenges and to address the needs of predictability and order required for international commerce, more formalized systems were adopted. Foremost among these solutions is the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, commonly known as the New York Convention. The New York Convention was adopted 60 years ago this week in 1958. There are comparable regional conventions such as the Panama Convention and the Riyadh Convention, but the New York Convention is recognized as the gold standard. Largely due to the New York Convention, the international enforceability of arbitral awards is now the rule, not the exception. At latest count, 159 countries had joined the New York Convention. In a 2018 Queen Mary survey, 97% of respondents indicated that they preferred arbitration over litigation, and as the survey explained, enforceability of awards continues to be perceived as arbitration's most valuable characteristic. Under the New York Convention, the basic rule is that the courts of each member country are obligated to enforce the arbitral awards issued in other member countries. With more than 150 participating countries, this means that an arbitral award issued in any one of those countries is going to be enforceable in virtually every other major country in the world. Another key provision of the New York Convention is that national courts of the participating countries must treat international arbitration awards on an equal footing with domestic arbitral awards. They cannot impose more onerous conditions or higher fees to enforce an international award. The New York Convention provides grounds to refuse recognition of the arbitral award, but these grounds, with one exception, are narrow and fairly self-evident, such as the arbitration agreement itself was invalid, the losing party was not provided notice of the arbitration was not conducted in accordance with the agreement, or the award is not yet binding or has been set aside. The one nettlesome ground is the public policy exception. Public policy is an amorphous concept that can be used to deny recognition of arbitral awards for a broad range of reasons. However, courts in most countries have interpreted this exception narrowly to apply only where the arbitral award violates basic notions of morality and justice. For a period of time, the courts of India had construed this exception broadly and took the position that any arbitral award based on an error of Indian law violated Indian public policy. After much criticism, India has since adopted rules that conform the public policy exception to the view held by most other countries. Until recently, the enforceability issue clearly favored arbitration over litigation. That may be changing, albeit slowly. Judgment enforcement can be based on domestic law, bilateral treaties, or multilateral conventions. As to domestic law, each country has its own requirements for the enforcement of other national court judgments. The U.S. and other common law countries have typically been receptive, even without a showing of reciprocity, and will enforce foreign judgments provided the issuing court and the underlying proceeding accorded with basic notions of due process. Other countries have been less receptive. To eliminate this unpredictability, countries have entered into bilateral agreements to recognize judgments issued by each other's national courts. There are also multilateral conventions to the same effect. However, there is nothing yet comparable to the New York Convention, either in terms of scope or the number of signatories. An encouraging development on this front is the Hague Choice of Court Convention, which was adopted in 2005, but only came into force in October 2015. The Chief Justice of the Supreme Court of Singapore has said that the Hague Convention is a game changer in the international enforceability of court judgments, and noted that the Hague Convention aims to do for court judgments what the New York Convention has done for arbitral awards. The Hague Choice of Court Convention is activated by the parties' inclusion in their private contract of a choice of forum provision, selecting the courts of a participating country as the exclusive forum for resolution of disputes. The participating countries agree that if the parties have such a clause in their contract, then the courts of any other participating country will defer to the chosen forum and will dismiss an action brought in violation of that clause. Moreover, and is relevant here, the convention also requires that the national courts of the participating countries recognize and enforce the judgments of the chosen country's courts. The Hague Convention is more limited in scope than the New York Convention, as there are several categories of cases that are exempted, including family law matters, employment disputes, and most intellectual property claims. The Hague Convention provides grounds for refusing recognition of a judgment similar to the grounds in the New York Convention. An additional ground is that the judgment is inconsistent with an earlier judgment issued by the court of a participating country. In addition, a national court can refuse recognition of that portion of a damages award that is non-compensatory, such as an award for punitive damages. The Hague Convention is slowly gaining adherence. The EU, Mexico, and Singapore are all participants. In addition, China, the United States, Montenegro, and Ukraine have all signed the convention and are awaiting ratification by their national legislatures. Assuming these countries become participating members, the added presence of the EU, the US, and China will presumably lead to the widespread adoption of the Hague Convention. There are other trends equalizing the choice of litigation or arbitration when it comes to enforcement. China is a dramatic illustration of this trend. Not only has China signed the Hague Choice of Court Convention, awaiting approval by the National People's Assembly, but China has also shown an increased willingness to enforce the judgments of other courts. Before 2016, China had never enforced a judgment issued by a common law court other than Hong Kong. Since then, however, Chinese courts have recognized and enforced a number of judgments from common law jurisdictions, including the United States. In certain situations, there are potential advantages to seeking enforcement of a judgment rather than an arbitral award, which sometimes means that it's advisable after securing an arbitral award to obtain a judgment confirming the award in the country of the arbitration, and then having that judgment enforced by the courts of a different country. For example, U.S. courts will enforce an arbitral award, will not enforce an arbitral award absent personal jurisdiction over the defendant. While jurisdiction typically can be based on the presence of the judgment debtor's assets, that's not always the case. For the enforcement of judgments, there is no such requirement to demonstrate personal jurisdiction. Another example is the statute of limitations. Under the Federal Arbitration Act in the United States, which implements the New York Convention, a party has 3 years from the issuance of the award to bring an action to enforce it. By contrast, the statute of limitations to enforce a judgment in New York is 10 years. Therefore, a party with a ruling that is more than 3 years but less than 10 years old would be better off in New York with a judgment than an arbitral award, assuming it was otherwise enforceable. An interesting question is whether the converse is possible. In other words, can you take a judgment and get it converted into an arbitral award and then take advantage of the New York Convention? The answer generally and historically is no. There's no recognized mechanism to take a judgment issued by a governmental tribunal and convert it into what is essentially a private arbitral ruling. In 2015, however, the DIFC courts in Dubai established a mechanism to do just that. When a party refuses to pay a judgment, it is considered a dispute subject to arbitration and upon which an arbitral award can be entered. This has been called an experiment without parallel in arbitration history. The procedure is still new and only applies where the party's contract contains a provision agreeing to it, so it is not yet clear whether the procedure will have any meaningful impact. But it offers an innovative approach that seeks the best of both worlds in terms of international enforcement. On balance, the ready enforceability of arbitral awards under the New York Convention is a factor that strongly favors arbitration over litigation. However, there are some developments, including the increased influence of the Hague Choice of Court Convention, that make this a closer call. In addition, there may be strategic reasons in a particular situation, that favor enforcement of a court judgment rather than an arbitral award. As with all else in litigation and arbitration, the final decision will come down to careful consideration of the particular circumstances at issue and the client's objectives. Thank you.
Thank you. Abhijit. Next.
Thanks. Good morning, everybody. I represent the business, so that's why Katharine has asked me to sit separately. What does that convey mean? I do not know. Don't try to attribute any motive to her. I am part of a very large business, as Katharine has also said. We are 104 years old. Our global turnover revenue is $20 billion. We operate in not 30, 40, but 60 countries where we have got offices. We export products to more than 100 countries. We have got 127,000 people working in those 60 countries. We have got 11 business verticals. We manufacture all kinds of products. We run power stations, hospitals, BPOs, educational institutions. We run banks, chemicals, media, entertainment, and explosives. So it's a huge organization. Now, you may be wondering, am I here to promote my group? The answer is absolutely no. I am only trying to tell you that please have some sympathy for me, who as general counsel has to manage this, at least the legal part of it. It's no wonder that I don't like dispute. My group does not like dispute. The reason is not only for cost and executive time, chasing the lawyers, etc. The main reason is that at the end of the day, I will lose my customer, joint venture partner. Actually, that's a key message to me. Some time back, we had a big dispute with Sumitomo Motor. Now, Sumitomo is a huge organization, much larger than us. And there was a dispute of $110 million. Not small, not big also. We have been asked to pay that. And as usual, we did not want to pay, so the matter ended up in arbitration. Their advisors were Howard Smith and ours were Hogan Lovells. At the time, how difficult my life is, there are two kinds of people in our own organization. Somebody tried to teach a lesson to Sumitomo, somebody like me, very docile, conservative, nice people who said that let's not fight, let's try to resolve in some form or the other. So I conspired with my lawyers in Hogan Lovells and eventually tried to convince the management that there is no point in fighting because at the end of the day, you will lose them. They are very big customers for us. It's a big organization. That shows the mentality of the entrepreneurial driven business group like us. And at the end of the day, to cut the story short, we sorted out with them. We are happily living ever after and we are doing good business with them. Dispute keep coming. It's a large group. But I have prepared a dispute resolution policy for the group. And when I told this to my group chairman, he said, why waste your time and energy on that? Because you require to consult a lot of people for doing that, etc. I said that my dispute resolution policy is just only one line, don't have any dispute. That is the dispute resolution policy. And honestly speaking, this is the policy that we run throughout the organization. Now, certainly, am I successful in every respect? No, not really, because it does not really depend on me whether I am being sued or not. I may be sued, which I have been a number of times. When I say I, it's really I represent the group. So therefore, I cannot avoid. But then certainly, in the dispute resolution policy, jokes apart, I tried to bring home the point that how you can really avoid the dispute, because it is very costly. As I said, it is not talking about the finance alone. It is the question of finally I am losing my joint venture partner. So we have developed some kind of early warning signals. I'm very sorry, my sincere apology to my lawyer friends, but at the end of the day, I have to see the interest of the group. So we have developed some kind of early warning signals inside the group. So we have trained the executives. Whenever you sense that there is a problem, what you should do, how you can escalate it. I'll give you one quick example that may be of some interest to you. We are developing a huge hotel near Trafalgar Square. It's a $1.4 billion project. There's an old war office just opposite Horsgard. So we bought that from the Ministry of Defense, 250-year lease, developing this into a hotel. No, we don't know how to run a hotel, so we have engaged Raffles, who will run the hotel. But it is a real estate project. Everything will be managed by us. Now we have got a partner. We are 51%, and there is a huge Spanish conglomerate who are owning 49% in the project. Now they are also powerful because the owner of that Spanish joint venture company was the former finance minister and ultimately the vice president of Spain. So after retirement, he created the conglomerate. So naturally they are also equally powerful, we are also equally powerful. Now here, if you do not develop some kind of early warning signals, then ultimately your $1.4 billion project will go for a toss. So this is how we really operate within the organization. Am I successful all the time? No, I'm not successful all the time. There are issues, there are problems. Right now I'm facing a lot of litigations in different parts of the world, but then try to avoid them as much as we can. Whether I like arbitration, whether I like litigation, as I said, I like neither. I was a part of ICC until last year. I was the global vice chairman of their commission on arbitration. So naturally, I had to somehow rather support the arbitration, no doubt about it. There's no other option. But sometimes litigation is preferable. Sometimes arbitration is preferable. Now, which one is preferable? It depends on the facts and circumstances of each and every case. I know it depends upon ultimately the documents also that you are creating. But then at the end of the day, the documents are all developed by us. So therefore, we can decide whether shall I litigate, shall I not litigate, shall I go for arbitration. In every document, especially in today's situation, I give a lot of importance to the mediation, which was not discussed in the morning. Normally, in every organization, mediation is some kind of done deal. When you draft the mediation clause, you just do some kind of cut and paste kind of job. But to us, to me personally, mediation is very, very important. Whether it is institutionalized mediation or whether it is some kind of ad hoc mediation, both are important to me. We spend time and energy to develop some kind of good processes of mediation so that if any dispute happens, then literally the parties sit down together to mediate and resolve. And I have got a huge amount of experiences. I have seen that how really mediation, if you have got the inclination, then how it can really resolve all kinds of disputes. When a dispute happens, as I said, that what do? I try to inculcate some kind of early warning signals amongst the people that whenever you sense some kind of dispute, and as I said that's why I have given you the width and breadth of our organization. It's such a huge organization. How do you really know when a dispute is occurring or not? And many times my experience shows, and I'm sure yours also, even at the lower level, there is a mismatch in chemistry. At the middle level, there is mismatch in body language. And that really creates some kind of dispute. And if it is not escalated at different level, then my experience shows really we have got all kinds of problem. And this is something which I try to address whenever I talk to the business people on a regular basis, that you try to smell the dispute. If you feel people down below the line have got problem with my customer, my partner, my somewhere else, then better you try to pick up the signal and the smell. It's actually important. If you ignore it, then you are in for trouble. Even at my seniority, my level, the moment I smell that there could be a problem, which I am sensing something in relation to my real estate Trafalgar Square project, I'm going to escalate it, which I have already done. So escalation, early warning signal, whether you do it in a formal way or informal way, you got to do it. If it is not addressed to, then dispute becomes arbitration and litigation and whatnot. We are a global organization. So we have got all kinds of jurisdictions, and every jurisdiction is different. India, there are 30 million cases pending in different courts. Of course, most of the cases, out of them 70 to 75% of the cases, all during in the I will say in the prehistoric days, 1950s, 60s, 1780s, 80s onwards. In the last 5 years, I was talking to the Chief Justice of India who came here recently, and he said that most of our cases in the last 5 years have been sorted out. But then there are cases before 5 years, before 10 years, these are all going on. But then that is no solace to me. At the end of the day, there are 30 million cases pending in different parts. Okay, so then how do I address them? We have got cases in India, so what do I do? Same goes with many other jurisdictions. So therefore, every litigation or every arbitration is quite costly to me. Even in India, arbitration is giving me a lot of headache because of all kinds of issues and problems. The new act has come into being, which hopefully will address some of the problems that we are facing. So that's what I said, that as a group operating worldwide, litigation, arbitration, everything is a problem to me. Okay, but I can't avoid. I don't create litigation, arbitration all the time. But then when I am dragged into, then what do I do? Then I have to look to you to support me. So therefore, external lawyers are needed, no doubt about it. What do I expect from the external lawyers? First and foremost thing, before giving the full briefing, and I engage external lawyers not only for litigation arbitration but for our businesses all over the world. And I always ask them, are you guys really interested to help us in resolving the matter, or you are here, okay, fine, I'll fight? Are you the disciples of President Donald Trump? If you are not, then better you are with us. Because don't have that attitude, let's see and let's try to teach a lesson to the other side. If you believe in my philosophy, then definitely I'm going to engage you. And most of the time I find that these days firms are also changing. They are also not interested to fight out. I can give you many examples, which I am sure you also have got many examples, where the firms literally persuade us not to litigate and try to avoid. We have got a huge case, I think 2 years back, against one of the largest automakers in the world. It's a German company. It is a powerhouse. And when I engaged, Baker McKenzie in London to advise us, they asked me the same question. Do you want us to really litigate, fight out, or you want to resolve the matter in some form or the other? I said that you try to find out. So to me, I am looking for this kind of firms, because I am not in the business of teaching lessons to anybody else. It's not going to work in the business. Otherwise, we wouldn't have continued for 104 years. So therefore, the whole intention is how to resolve it. So, are you with me? It's not George Bush classic question. I'm asking very generally that are you with me? If you are with me, then you are the person for me. You are the external firm for me. So in the external firm, when I engage them, I try to see that what kind of, knowledge, wisdom they have got. Actually, that's very, very important. And most of the major law firms, global law firms, they have got this kind of wisdom. Nobody wants to fight. But then for that, you need to understand our business. So therefore, if you don't know the business, because disputes are coming not because I don't like X or X does not like me. It is a question of complex businesses. So therefore, it is important that you understand the business to a great extent. And if you understand the business, then definitely you will be able to advise me whether it is good for us to litigate, to move, to settle in some form or the others. Two quick more points. One point is when litigation happens, why I am telling it is very costly. I am not the creator of any litigation. I am a poor man sitting in our global headquarters. So therefore, when it is created at the business level, I have to involve them. And there are plenty of them. We have got a huge problem in Russia. And where we have supplied our own, we manufacture buses, lorries, trucks, light commercial vehicle under British Leyland. We acquired British Leyland in 1986-87. So we supplied buses in Russia and we are not being paid. And that goes back a couple of years and millions of dollars are pending. Now, certainly Russia is not an ideal place to litigate, but you have to litigate there. So you require that kind of legal firm who can help you in winning or in advising you, because the customers represent a mafia. So what do I do in such an event? So you require that kind of legal firm also, which is very unfortunate. Last point is how do we avoid dispute? And this is really my favorite subject. Before joining the Hinduja group, I spent 20 years in India, and I was the general counsel for 7 largest companies in India. One of them was Suzuki. Sometime back, around 20 years back in 1990, when I was a general counsel in Suzuki. No, I'm not that old, but I was fortunate enough to get some good positions when I was pretty young. I got, I still remember that there's a huge dispute. Government of India was owning 50% of Suzuki, India, and Suzuki Motor Corporation in Japan, they were owning 50%. It's a large company, $20 billion company, one single company. It produces 1.5 million cars every single year in India. Its daily production is 2,200 cars, daily production. Every single day it produces. It's a large company. And Government of India is Government of India, and Suzuki is Suzuki. Government does not know how to manufacture cars. Suzuki does not know how government runs. So therefore, there is a problem, and it was a huge dispute. It became international dispute. It went on for 1 year. And eventually it went to international ICC arbitration in London. No, it was not sorted out through arbitration. It was sorted out at the political level. And one fine morning, the industry minister in India called me and said that we have decided politically between the two countries, Japan and India, to sort out these issues. So here are the documents, produce the documents. And once the disputes are over, then the industry minister in India asked me, Abhijit, now that you are so soaked in these disputes, tell me why did it happen? I said it happened because unfortunately the shareholders agreement, joint venture agreement, what you prepared was patently wrong. It was not really practically drafted. He said, what do you mean by this? He said, you imagine you have got a $20 billion company. You have got a board of directors. 50% represent Government of India. They're all hardcore bureaucrats. And then 50% is technical people from Suzuki. And there is a chairman who is appointed on an alternate basis. 5 years you, 5 years me. There is a managing director appointed 5 years you and 5 years me. Now in the board, nobody has got a casting vote. Now please tell me how on earth you can run a $20 billion company in that fashion. So there was a problem in your documentation. Because in 1981, when the Indian Prime Minister visited Japan, at that time, she, Mrs. Gandhi, was responsible of really bringing Suzuki into India. Everything was hunky-dory, I love you, you love me. So therefore, somehow or rather, a defective joint venture agreement and management structures were created. And eventually, the minister told me something very interesting. He said that now you go and solve it. But anyway, that's a different thing altogether. So my point that I have been telling to businesses all through, please develop a proper agreement. Even on the dispute resolution, please don't do cut and paste. You have a proper dispute resolution clause. Otherwise, if you have got a good agreement, good documentations, then obviously half of your problem are over. Last point I will tell, whenever there are, presidential delegation from different countries, prime ministerial delegation from different countries, they visit London, being the global headquarters, and our group is politically hugely powerful and connected. They always come, we sign agreements, and most of the time, I am the spoiler. I always say that please do not sign. If you want to do photo op, please do it, but do not sign a binding agreement with the government. Do a non-binding agreement. When everything comes down, then you think of what kind of legally binding agreement you are going to do. And if you do that, much of your problems will be over. Thank you very much.
Thank you, Abhijit. That was very interesting insights on the subject. And I think that the message that came away is that if you basically have an objective that you need a dispute resolution policy, and make sure you give that to the people drafting your contracts, at least they'll have a debate about what you really want. I thought there were really good, interesting points raised there. One is I didn't realise that the Swiss were going to be taken over by the English. It must be after Brexit. And so that's really good to know. And the other thing is, which is interesting about enforcement, yet, I mean, those who are not British, and a lot of you aren't here, will know that there's something called Brexit going on at the moment. And there's more probably academic discussion going on as to what we'll do after Brexit, about how we'll enforce our judgments within Europe. And it was very interesting to see about the Hague Convention is, it's EU that has signed that, not the UK. So there's, I think it depends which country you are in the world as to what you're going to look for. And this is probably something we need to think about, when we're going back, if you are going to have an English law clause, is that how you're going to enforce it, whether it's going to be judgment or arbitration. I must admit that, the first thing we all said, oh my God, all our contracts have to have arbitration clauses. But I think we're actually rolled back from that. We've got a couple of minutes for questions, and I think that I'm sure there's a lot of people here, and I'd like to take some questions from people. I mean, I'd be quite interested. One of the things that Thomas dealt with was obviously interim relief and the difference between the courts and arbitration. As we have Wilfred from AAA, I'd be interested, your thoughts on that.
Well, I mean, actually, for almost 30 years, I was in-house counsel and general counsel. So, I mean, I've got perhaps a slightly different view. As Abhijit said, when you were with the ICC, I mean, you're trying to promote arbitration. But I think the important thing is that you look at each situation, as was said, and decide whether you are happy with a state court litigation clause or arbitration. I mean, when I advised the company on our international contracts, obviously, in many cases, arbitration was what we chose. But there are jurisdictions, clearly, where litigation might be preferable. And so I think it is horses for courses and not just one type of clause that you use.
I was more interested also between sort of interim relief injunctions, because obviously the LCIA now have requirement for an expedited arbitrator. I've also done it in the States, where we've had an expedited arbitrator to I must admit, every time I've done it, I've been defending it, so I've been very pleased we haven't had it. But it is something that's becoming more prevalent, I think, within arbitration. I think probably the interesting thing, if anybody's got any experience, is one thing is getting the interim relief, which you can get an emergency arbitrator again, but actually the enforcement of it. Has anybody got some experience of that?
I don't have experience, but anecdotally, what I am hearing now is that the various institutions which are adopting these procedures for interim relief are finding that most of them are being voluntarily complied with. And from what I am hearing, the reason for the voluntary compliance is the expectation of the parties is that there's going to be further proceedings, and they don't want the arbitral tribunal to be on their wrong side.
Thank you. Another theme I thought, which was quite interesting, which Michelle said, was talking, and obviously there's a huge amount to cover here when we're looking at the differences between arbitration and litigation. But one of the key things, obviously, is things like confidentiality and influencing the tribunal, really, depending on the quality of the judiciary in your area compared to the tribunal, which sometimes you can influence. You know, depending on where you are, and you can also, I mean, with us, I'm sure, same with most people, you deciding whether you want to send it as common law or civil law. I wonder if anybody has any insights and thoughts on that area, because there are quite a few people here who think of those themes.
Well, definitely you don't want to litigate in Italy. That's
really, I must remember that one. Well,
although in defense of Italy, I've heard that the Milan courts are actually pretty good, and this is.
You know that Milan was under Austrian domination.
I did go to Milan once, actually.
My point was actually you need to look very much at the specifics, because certain parts of the Milan courts are known for their efficiency. So I don't want to tar all of Italy, but
well, it depends who you're acting for, though, doesn't it? Really, because if you have a no disputes policy. Then it might be to go somewhere where it takes so long, the other side just give up. So it does have its advantages.
To drag something along forever, then
yes,
it's ideal to defend in Italy.
Yeah, I must excuse me, making note of that. Go to Italy. Can we do it under English law, or can we in Milan? Good shopping. Any other particular questions, people, burning issues people have? That any of the panel have any particular questions? Yes, please.
Yeah, Yeah. I could actually ask Matthew directly at the dinner we're having tonight, but perhaps it's a question of general interest. I would be interested whether you have seen any statistics on the numbers of arbitral tribunals that were actually executed at the New York Convention of '58. We're discussing that a lot. I've never ever found such numbers, and I mean, my experience is that you, at the very end, land before a state court again, waving with the New York Convention, saying this is a valid title, now go for it. And my experience is that they say, okay, let's have a look, you know, and let's see whether we can actually execute. So, do you have? Can you give us any indication or impression, or? You know?
Yeah, well, I don't have numbers. I will say, at least in the U.S., it's a fairly streamlined procedure. If you go to court with an arbitral award issued in any New York Convention participating country, it will be enforced. Very, very narrow grounds to challenge the award.
Same for Switzerland.
Yeah. So I don't know the numbers, but I assume it's in the many thousands.
Any more questions?
Yes.
Yes.
Just from the practical side, when you're thinking of drafting up jurisdiction clauses, or would I say rather litigation clauses, one might think, well, look, what's the best jurisdiction to go? And where do I get my decision, which will be favorable to me? But sometimes, and that's my experience, a favorable decision is not always an enforceable decision. So, do you have any tips, tricks to think beyond the decision of the court, which could be a nice piece of paper against the wall, or getting paid?
I would say that is the issue. You have to balance the ability to get the favorable ruling against the enforceability. I don't have any secret.
About what do you think? I would say, I would think about where are the assets of the judgment, possible judgment debtor, which is always a good tip.
Right. That's probably the most important consideration. Where are the assets? Where can you enforce the judgment?
Can I say something?
Yes,
Yeah.
come up here.
Yeah, I think that's really the mother of all questions, and we don't have the answer to that. But asset is one part of the story, but then definitely, if the enforceability is very poor, then certainly it's not going to be helpful. I think what I try to do, or what as a group what we try to do, is that normally we try to push English law and English court jurisdiction, and then ICC arbitration, failing which LCI arbitration. When you deal with the global corporation, this is how we do. And I have seen that, English court, English jurisdiction, obviously I need not have to promote anything. But then on behalf of Law Society, these days I am promoting English court and English jurisdiction, but thanks to Brexit. But then honestly speaking, if I go for it, I'm very, very, very comfortable. But then it does not happen all the time. Like when I am signing contract in Switzerland, somehow or other I am always coming under the jurisdiction of the Swiss courts, because many times they don't agree. But my biggest problem is not in Europe. My biggest problem, not even in Asia, my biggest problem is in Middle East. So certainly, which jurisdiction? Well, I think UAE courts. Now, it is the Sultan who writes the law. In one fine morning, if he has got good mood, he will write something good, and in the afternoon, the law will be changed. I'm telling very jocularly, because we have got very good presence in UAE. Middle East, we do business with Iran. Now, that is a country where any kind of arbitration, whatever award you get from all over the world, it does not get enforced. It is very difficult. So my one-line answer, you have to have different yardsticks for different kinds of contract. Pan Europe, safely I will go for English law, English court, English jurisdiction. But in the Middle East, I have to go in for the localized law. But there I got to be very, very careful. In Africa, I have seen Swiss jurisdiction or English law jurisdiction are always acceptable. That is not a problem. In Asia, again, English law is not a problem. In India, English law is not a problem. But it all depends. Last but not the least, I had a very good experience in handling an IPR related matter in Estonia. And my whole impression about that country has undergone changes. When we started the battle, nobody knew what was IPR in Estonia. And I'm talking about something quite long back, 2005, 2006. For 3 years, I fought in 10 courts. And eventually the final judgment came from the Supreme Court of Estonia, who clearly told us that we are not as matured as the English court and English law. So can you, quote unquote, educate us on the fineness, nitty-gritties of the IPRs? And we, quote unquote, educated them. And they were really good enough to give a judgment in our favor. That's not the point. So don't get misled by the smallness of the country or the bigness of the country.
Well, thank you. I think we've just about reached our time. Do I have momentum?
I think we have exceeded.
Sorry,
Yeah,
I apologise. Do you want to give momentum to it?
Yes.
Yeah.
Now, I would request. Yeah, that's true.
I've done it once now. I know what to do. I've practiced. Thank you.
It was really a very nice speech. Presentation. So I would request Katharine to present the memento one by one.
Can I give this to Abhijit? Thank you ever so much.
Sorry.
That's great. Thank you. I'll take it. Thank you.
Oh, thank you.
That needs to be declared a whole task when you.
Thank you.
And thank you to Michelle as well. Nice warm. Thank you very much, everybody.